Hello, Mike.
Good morning. My apologies. I had a little technical difficulty this morning.
Okay. And Daryl, Mr. Redman, are you with us? Well, Mike, while we're figuring out about Daryl, I had already mentioned to Mr. Olson that we need to have a discussion about witnesses and whether or not they're going to be excluded.
All right.
Obviously, Mr. Burns, as a party, is entitled to sit through the entire arbitration. I guess I'd like to hear from you guys as your view of your witnesses and whether or not they are a party or just fact witnesses, and your opinion on whether they should be excluded.
Okay. Mr. Redman is no longer a unit owner or board member at the condominium. So he's just a fact witness. The other two witnesses, though, are party representatives, and so I would ask that they be allowed to remain on the line.
Okay. Mr. Olson?
If they are indeed party representatives, then no objection to that, but otherwise I would ask that witnesses be excluded until it's their turn to testify.
Understood. Mike, why don't you reach out to Mr. Redman and tell him that you will contact him when it's his time to testify?
That sounds just fine. I will send him an email right now.
Okay. And I don't know whether he is listening right now or not, but ask him to sign off.
Okay.
I mean, I can remove him, I guess, as the host, but don't want to be blunt.
I just sent him an email and let him know that I will call him when it's time to testify.
Okay, great. It looks like he has jumped off. So perfect. So for just a quick introduction for those of you who don't know me, I've known Mr. Vial for years, but I'm Jim Oliver. I'm a court-appointed arbitrator for the matter. I've been coming up on 27 years of practicing law in Oregon, and for the last 15 or so, I've done a lot of arbitrations as the arbitrator. Of course, I did a lot as a litigator in the first 15 years. Although I've done a lot of arbitrations, I have done very few using Zoom. So hopefully everything goes smoothly. I think I know how to run it, but technical difficulties happen, and if they do, we'll do our best to plow through. I mentioned earlier, and I'll repeat it, that I think it's best if you're not speaking that you stay on mute, and then unmute yourself when it's time for you to speak. I am not wearing a suit coat, but I don't want anyone to take that as a sign that I am not treating this proceeding with all the seriousness it deserves. My home office gets a little stuffy. And counsel, feel free to do the same should you so desire, that is, removing your suit coats. Both attorneys have anticipated that this hearing will take about 2 hours. My recommendation is that we try to go straight through. That is, we don't take a lunch break if we get to noon and we're still going. Of course, a personal break can be taken at any time. Just reach out, let us know. So I'd like to move now to pre-hearing matters, and this is for the attorneys. First of all, does anyone have any objection to any of the material that has been submitted to me?
I don't.
I do not.
Okay, so everything that has been submitted to me will now be deemed admitted. We talked about the witnesses. So do you guys have any pre-hearing matters that you'd like to discuss?
I do not, no.
I don't either, other than to say I think this should be fairly streamlined.
Great, and I appreciate that. So do the counsel wish to give opening statements?
I would like to.
Okay. Mr. Olson, you can proceed.
Thank you, Mr. Oliver, and good morning, everyone, and good morning, Mike.
Morning.
Today I intend to offer into evidence exhibits 1 through 6 that accompanied Mr. Burns' pre-hearing brief yesterday, and I will also have my client discuss the email that we received last night from Mr. Vial. But this is a narrowly focused case. The issues are whether Mr. Burns acquired his unit as the result of a foreclosure of the prior owner's first mortgage or deed of trust, whether any of the assessments against the unit or its prior owner became due prior to Mr. Burns' acquisition of title to his unit, whether Mr. Burns is or was personally liable for such assessments, whether the HOA overcharged Mr. Burns in the amount of $16,670, and whether Mr. Burns overpaid the HOA in that amount. The evidence will show that at all relevant times, Mr. Burns was a unit owner and a member of defendant HOA, that Mr. Burns acquired title to his unit in November 2010 as a result of a foreclosure of the prior owner's deed of trust, that assessments against the unit or its prior owner became due prior to Mr. Burns' acquisition of title to his unit, that Mr. Burns is and was not personally liable for such assessments, that the HOA did indeed overcharge him in the amount of $16,670, that he mistakenly overpaid that amount. Importantly, that Mr. Burns did not discover his overpayment and reasonably could not have discovered it until sometime before defendant's July 17, 2019 board meeting. I think the evidence will show that he learned of this issue in mid to late October 2018 at the earliest, and that discovery occurred within 2 years of Mr. Burns filing his complaint on October 8, 2020. There was a July 17, 2019 recorded board meeting, and the testimony will show that Mr. Burns and the HOA reached an agreement that the HOA would promptly refund the full amount of his overpayment in return for Mr. Burns not pursuing litigation. And finally, the evidence will show that the HOA has not refunded any portion of Mr. Burns' overpayment. Thank you.
Thank you, Mr. Olson. Mr. Vial.
Mr. Oliver, in the interest of time, I'm mostly just going to rely on the pre-hearing brief that I submitted, but I did want to point out a couple of issues, or emphasize a couple of issues, rather, starting with the association's legal entitlement to collect the assessment. And this really is kind of a basic issue. We've submitted the resolution that the association adopted that levied that assessment on a month-to-month basis over a term of a number of years. The language of the resolution is clear. The owners were obligated to pay that assessment on a month-to-month basis, and that month-to-month payment tracked the association's loan payment. So under both the Condominium Act and the association's governing documents, if the association takes out a loan, the payment it has to make to the bank each month is a common expense of the association. And each owner is responsible for their allocable share of that common expense. So the common expense is created each month with the association's obligation to pay that loan payment. Likewise, the assessment on the owner is levied each month to pay their share of that payment. The resolution's language is pretty straightforward in that regard. Now, owners have the option of prepaying the entire principal amount of the loan that would have been allocable to their unit. So the association's common expense, that principal amount divided up amongst the unit owners, the owners have the option of paying that in advance, so the association could take that money and apply it to the principal balance of their loan, and then no longer have any interest obligation on that portion of the principal going forward. So while prepayment was an option, the entire balance was not due and payable at any point. No owner was ever obligated to pay the entire balance up front. The balance was always supposed to be paid on a month-to-month basis. The obligation to pay didn't arise until each month's payment was due. And so under the clear language of the statute, the assessments that the association levied against Mr. Burns were not due until the association required payment of that assessment each month. And that assessment obligation was not wiped out at foreclosure, which I think was clear to everybody, including Mr. Burns. It was certainly clear to the seller of the unit, the financial institution that took the unit back in foreclosure, and it was clear to the title company because they included that monthly special assessment obligation on Mr. Burns' closing statement, as you've seen in the documents we've provided to you. It was also obviously clear to Mr. Burns. He got a copy of all these documents. He agreed to buy the unit under those conditions, and he made the special assessment payments all the way through until he finally did a prepayment of his remaining obligation some years after he purchased the unit. This is coming up now because Mr. Burns and the association have been involved in a series of lawsuits over the years. I'll add a grain of salt here that I may have missed one, but I know of at least 4 offhand where Mr. Burns has either sued the association, or in one case, the association sued Mr. Burns in order to obtain an injunction against him from committing various violations of the association's governing documents. And in each of those matters, he's alleged different types of financial improprieties. He had ample opportunity to examine all of the different financial transactions between himself and the association. He availed himself of that opportunity to the point where he made a number of, in our view, unfounded allegations. And he had the advice of counsel at various times in making all of these allegations. If there was a claim to be discovered in the exercise of reasonable care, he would have discovered it probably back in 2015 when the first lawsuit was filed. The document that we submitted to you from Mr. Hatch, that was an email that Mr. Hatch received, and we will have Mr. Hatch testify about that, but it also makes it crystal clear that Mr. Burns was making the precise allegation that he makes now more than 2 years before his complaint was filed. And under the case law that we cited to you in the brief, there's just no way that he can maintain a claim for unjust enrichment. There's no way that he can maintain his declaratory judgment action in light of these facts. In terms of the supposed agreement, I'm going to rely on the brief and rely on our witness testimony. And with that, I'll yield, and we can turn it back over to Mr. Olson for his case.
Okay, thank you, Mr. Vial. Mr. Olson, are you ready to proceed with plaintiff's case?
I am, Mr. Oliver. Thank you.
Okay, call your first witness, please.
I call Tom Burns.
Okay, Mr. Burns, you can unmute yourself now. I'm going to swear you in now, Mr. Burns. I'd ask you to raise your right hand. Mr. Burns, do you swear or affirm that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Olson, you can proceed.
Thank you. For the record, Mr. Burns, would you state your full name, please?
Thomas Scott Burns.
And what is your age?
69.
What is your occupation?
Retired.
And where do you live at present?
5170 Northwest Neocani Avenue, Unit 8, 97229.
And is that part of the Country Club Condominium Association?
Yes.
Where did you live previously?
Across the driveway in Unit 28 in 5180 Northwest Neocani Avenue.
And is that the unit that's at issue in this case today?
Yes.
And when did you live there at Unit 28?
Since 2010 till summer of 2018.
Okay. And did you purchase that unit on November 23rd, 2010?
Yes.
Did you purchase it from the Oregon Housing and Community Services Department?
Yep.
Did you obtain title to your unit as the result of a foreclosure of the prior owner's deed of trust?
Yes.
And how much did you pay for the unit?
$60,000.
Okay. Yesterday we emailed out some exhibits, and I would call your attention to what I've named Exhibit 1, the Trustees' Deed to the Oregon Housing and Community Service Department. Have you seen that?
Yes, I have.
And what does this Trustees' Deed show, in your opinion?
Mr. Olson,
Yes, sir.
let me interrupt. Are you planning on showing or sharing your screen and showing the exhibits for the witness, or is the witness just viewing it at his home?
The latter, I was thinking.
Okay.
Can I
Mr.
show
Vial,
it?
do you have any objection to that?
Pardon? Do I?
Mike, you need to unmute.
Mike.
All right. Probably won't be the last time. I don't have any objection, Mr. Oliver, as long as you can see the document as well. I think this will be just fine. With the caveat that I will probably want to share my screen at some point.
Okay, we can work that out. And I apologize for interrupting, Mr. Olson, but I should have discussed that in the beginning. So you're referring to Exhibit 1 that was for your arbitration brief, not with your pre-hearing statement. Correct? Okay. And I do have all the exhibits available to me, obviously. So please proceed. Sorry for the interruption.
No worries. Thank you. So, Mr. Burns, does this Trustees' Deed to the Oregon Housing and Community Service Department show that the prior owner defaulted?
Yes.
Okay. And that the Oregon Housing and Community Services Department obtained the Trustees' Deed to the unit as a result of that foreclosure?
Yes.
I would offer Exhibit 1.
No need to offer exhibits. They've all been deemed admitted.
Very good. Thank you. And Mr. Burns, I would refer you to what we emailed out yesterday as Exhibit 2. It's a 2-page Community Association Partners, LLC, escrow demand statement. Do you have a copy of that?
It's separate from this list of exhibits.
It is what we emailed out yesterday afternoon as Exhibit 2.
Exhibit 2. I have Exhibit 2. That shows the escrow demand statement.
Okay. And so what does this escrow demand statement show?
The seller's name, Oregon Housing and Community Services Department, and the accounting of the closing
Okay.
escrow.
And you also sent out yesterday what have been labeled Exhibits 3 and 4. Exhibit 3 being the final buyer's settlement statement, and Exhibit 4 being the final settlement statement, the HUD-1 statement. Do you have copies of those?
Yes.
And so what do all these documents show? Exhibits 2, 3, and 4.
Well, I purchased the unit for $60,000 from this Housing and Urban Development.
Okay. When you purchased your unit, did you have to pay any assessments to the HOA that were attributable to the prior owner?
Yes.
Okay, and was that amount $16,670?
That's the full assessment.
Okay, and did you pay that? $16,670 to the HOA?
Not until 2015.
Ultimately, did you pay it?
Yes.
The full amount?
Yes, monthly payments were included in my HOA dues, subject to late fees and such, and I did that until I paid it off in May of 2015.
Okay. And do you have any copies of receipts and accountings? Do you have
Yes.
Exhibit 5 in front of you?
That's right. That's from the BPM Property Management Accounting.
Okay, and what do these receipts and accountings show?
Monthly payments.
Do they show that you paid $16,670?
It showed I paid up. Well, yes, it shows, and it also shows when I paid the balance off in May 2015, the remaining balance.
When did you discover that you might not have been responsible for these $16,670 in assessments?
Latter part of October on.
October what?
Of 2018.
And how did you come to this this view or understanding that you might not have been responsible for those?
A suggestion by Eric Hogue to check the ORS statutes regarding foreclosure.
And was that in mid to late October 2018?
Right.
Mr. Vial mentioned in his opening statement that you should have discovered this sooner. Why did you not discover it sooner?
The focus was mainly on the fact that they weren't deducting interest. The whole lawsuit of Eric, Cherie, and Harvey pertained to the interest that wasn't being collected.
Okay. Why did you not pursue your claims sooner in this case?
I had no idea about the foreclosure. I was just trying to get out from under it because it was a high rate of interest.
Okay. When did you bring the alleged overpayment to the attention of the HOA?
The demand letter.
When?
Was January 9th of 2019.
And did you have some back and forth discussion with the HOA about this alleged overpayment?
From that point forward.
Okay. And did the HOA ever say that they would refund you the $16,670?
In July of 2019.
Was that at a recorded board meeting on July 17, 2019?
Correct.
And was that recorded with permission?
Yes, they're recording.
Okay. I don't know if we need to, Mr. Oliver, I don't know if we need to listen to that recording right now, given defendants' admission in their pre-hearing brief yesterday that the board did at this meeting approve the refund.
I can tell counsel I listened to the recording that was submitted. If maybe now isn't the appropriate time, but I do have a question regarding that meeting that was recorded with your permission.
Oh, yes, please.
Mr. Burns, were you in attendance at that meeting that was recorded?
No.
Okay. That was my question. All right. Mr. Olson, please proceed.
Thank you. And so that was Exhibit 6, emailed yesterday. Let's talk about the September 16, 2018 email from you to John Hatch that we saw last night from Mr. Vial. Have you seen that email?
Yes.
Okay. And does it contain a copy of an email from you to John Hatch dated September 16, 2018?
Yes.
Do you recall sending that email to Mr. Hatch?
Yes.
What was that email about?
The special interest, or they were arguing whether it's a special or a serial assessment regarding the interest that had not been collected and was being now collected from current homeowners that had owned their homes since the origination of the assessment.
Did it have anything to do with the $16,670 that you allege you overpaid to the HOA?
That email was specifically dealing with the interest assessed. I was assessed $3,677 and others as much as $5,000.
Okay. Did it have anything to do with the $16,670 that you allege you paid to the HOA?
No.
Okay. And what did you mean when you wrote you were a post-assessment owner?
That there's a exhibit which shows, let me see, it shows the HOA's breakdown. It's exhibit 5,
Exhibit 5?
page 2 and 3. That was provided by the HOA, showing balances of all the previous presidents still being owed because they sold. John Hatch unit in particular is Bill Cook's unit 43, that Bill Cook was able to get away without having to pay the interest.
What did you mean by you were a post-assessment owner, close quote?
I was a buyer after the assessment had been created, not at the origination.
And this email was concerning interest, is that right?
Yes.
Not the $16,670 that you had paid already.
Correct.
Okay. Does this email mean that you knew about your overpayment to the HOA more than 2 years prior to your filing of the lawsuit?
No.
Okay. What are you asking the arbitrator to do for you today?
Well, the $16,670 to be returned, as agreed.
Okay. All right. That's all I have on direct at this time.
Thank you, Mr. Olson. Mr. Vial, cross-examination.
Yes. Let's start where Mr. Olson left off. You said you want the association to pay you in excess of $16,000 as agreed. What was that agreement, Mr. Burns?
That's the board meeting in July 17th, 2019.
No, I mean, what did you agree to do in exchange for that money?
To not pursue a lawsuit.
Who did you make that agreement with?
That was the basis of the first demand letter. And I made it. I did nothing. I just heard the outcome of the vote, and then patiently waited to receive the payment.
So prior to that vote, you didn't go to the board of directors and say, if you refund me this money, I won't file a lawsuit against you.
No.
All right.
Well, the demand letter basically says that, pay it, and we won't proceed.
I don't think we have a demand letter in evidence, but just to be clear, there was you didn't attend the meeting where the board voted to refund you the money, right?
Correct.
Okay. And you didn't go to a previous board meeting and address the board and say something to the effect of, if you refund me this money, I won't sue you, correct?
Didn't happen.
All right.
Correct.
Now, you agree that you've been involved in a number of lawsuits with the association starting in about, 2015?
That has nothing to do with this case.
In those lawsuits, have you made various allegations of financial improprieties against the association?
I addressed the interest fraud.
have you claimed that you were overcharged by the association for assessments, or that your assessments were improperly calculated?
I claimed that I didn't owe the $3,677 amount of interest that you had sent me a collection letter regarding.
Did you ever report the association to the United States Comptroller of the Currency alleging financial fraud?
That's right, dealing with the interest.
Yeah, when was that?
Oh, 13, 14.
About 2014, is that what you said?
13-ish. That's when started being abused by the board with the legal consequences.
Okay. Now, you said, actually, I'm not going to put words in your mouth. I just want to clarify your testimony. My understanding is that you've testified that you learned of this alleged overpayment in the course of Eric Hoag's lawsuit against the association. Is that right?
No. I understood the interest fraud from that lawsuit that was created by you originally with the CAP property management company at that time, prior to BPM, that the HOA sued for this fraud.
When did you learn, or when did you come to believe that the association wasn't entitled to collect the assessment, the special assessment from you?
Which special assessment are you referring to? The interest?
The special assessment that's at issue today.
That was when I discovered the statute in late October.
How did you discover that?
By searching through the ORS statutes regarding foreclosure.
You just happened to go looking for the foreclosure. Now, which statutes were you looking at?
The one that I have presented.
And did you just happen to be looking through the Oregon Revised Statutes and notice that?
Yes, I've spent a lot of hours at the law library.
Okay. You didn't learn any new facts regarding this special assessment within 2 years of filing your lawsuit, though, did you?
Say that again?
I'm going to ask you a different question. You knew that the association was going to levy a monthly serial special assessment against you when you purchased the unit originally, correct?
It was in question because the terms were jostled around, and at the time of signing, it wasn't even brought up, although it was in the paper form, and it stipulated a monthly payment.
You actually made those monthly payments starting at the time that you purchased your unit and continuing thereafter until you made all of the payments or paid the entire balance. Is that right?
That's right.
Okay. Did you know what the special assessment was for?
The construction contract.
All right. So you knew the association was levying that assessment from the beginning. You knew what the assessment was for from the beginning, correct?
Yes.
All right. I don't think I have anything else for this witness, Mr. Oliver.
Unmute yourself, Mr. Oliver.
Yep, probably happened again. Thank you, Mr. Vial. Mr. Olson, do you have any redirect?
I do. A couple of questions, please. Mr. Burns, in the demand letter that you sent to the board in January 2019, did you say, in effect, pay or you would sue?
That's what the attorney said. I had an attorney that wrote the letter.
Okay, so your demand letter did say that.
Yeah, basically to avoid litigation, please take care of it.
And did Eric Hoag tell you to look in the Oregon revised statutes?
Did Eric what?
Did Eric Hogue tell you to look in the Oregon revised statutes?
Yes.
Is that why you began looking in the ORS?
Yes.
Is that why you then discovered this statute
Yes.
that's at issue in this case?
Yes.
And when did Eric Hogue tell you to look at the statutes? Was that mid to late October 2018?
Yes.
Okay, thank you. That's all I have.
Okay, thank you, Mr. Olson. Mr. Olson, do you have any other witnesses?
No, I do not. Thank you.
Okay. Are you resting your case at this point?
I am. Thank you.
Okay. Mr. Vial, are you ready to proceed?
I am. I'd like to first call John Hatch.
Okay, Mr. Hatch, if you could unmute yourself.
I'm unmuted.
Thank you. I'm going to swear you in now. If you raise your right hand. Mr. Hatch, do you swear or affirm that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can proceed, Mr. Vial.
Thank you. Mr. Hatch, do you own a unit at the Country Club condominium?
Yes, number 43.
All right. When did you acquire that unit?
The 11th of March, 2015.
Do you currently serve on the association's board of directors?
Yes.
Have you served on the, let me back up here. When did your current service on the board start?
Just in the last 6 months, 5 or 6 months.
Did you previously serve on the association's board of directors?
Yeah, in 2017, I joined the board.
All right. During that previous term of service in 2017, did you have any interactions with Mr. Burns?
Yes.
That's
yeah,
okay.
I'll
follow up here. Did Mr. Burns attend meetings from time to time, meetings of the board of directors?
Yes.
Right. And did Mr. Burns send email correspondence from time to time?
Oh, yes.
During that 2017 period that you served on the board, did Mr. Burns ever make any sort of allegation or claim of financial impropriety or accounting irregularities against the association?
Yes. There's numerous emails during that period. He had been fined by the homeowners so previously, before my time. He'd been fined, and there'd been an ongoing rhetoric about that, and of course the court case.
Now, I have submitted the special assessment resolution number 12 into evidence here, and I'm going to attempt to share my screen so you can see it at the same time. And by attempt, I mean, let's see here. I'm not sure that I can do that. I'm sorry, Mr. Oliver. It doesn't appear that I have screen sharing enabled oh, yes, I do. Never mind. I'm sorry. Okay, now I've got it. All right, so, Mr. Hatch, I'm going to share this resolution. Can you see that?
Yep.
All right. Do you recognize this as the resolution levying the monthly serial special assessment for the construction and repair project?
Yes.
All right. Now, you weren't a unit owner or a member of
No.
the association when this document was adopted, were you?
No.
All right. But you were on the board of directors while the association was still collecting payments on a monthly basis from some owners, correct?
Yes, and I was aware when I bought the unit. I was aware of assessment, and so I made sure that I wasn't responsible for it in the closing.
All right. Now, as a member of the board of directors during the period that this assessment was being levied and collected from owners, did you have an understanding that owners were only obligated to pay the special assessment, the serial special assessment payment that was due that month?
Yeah. Yeah, the board kept tabs on who was paying and if anyone was late. Yeah.
Would you say that most of the owners elected not to prepay the special assessment payments, but rather to pay the assessments that became due each month?
Yeah. Yeah. Yes.
All right. And to be clear, you were not on the board of directors when Mr. Burns alleges that this agreement to refund him money was made. Is that right?
I was on the board 2017 through 19, 2 years.
Right. I'm sorry, I'm going to stop sharing this document. All right. This email that you received that we've submitted into evidence, that you forwarded to me last night, looks like Mr. Burns' cat is joined. All right. This email that you forwarded to us, or forwarded to me, did you have an understanding of what Mr. Burns was talking about when he sent you that email?
Well, I was trying to find the first occurrence of documented occurrence of when this, when I was aware of this, and I, from the wording here, since I am a post-assessment owner, as you are, were, I also have the new assessment voided, as you do. So I immediately looked at that, and you can see that I passed to the treasurer, and the treasurer said that to Tom that he did assume the assessment. You made payments on it through 2015. So I assume that was the first knowledge I had that he may have a claim on, that he was voided.
So, just to be clear, this email from September 16th, 2018, you read that as being related to Mr. Burns' claim or allegation that he was not legally obligated to pay the serial special assessment that is at issue here.
Well, yeah, when I looked at that, I think my immediate response was to look at the amount that he was owed. And then I was just puzzled by it. But then it was Sandra, the treasurer, who said you did assume the assessment, you made payments on it through. So she interpreted it the way it looks, that he's claiming that he's not, because he bought a unit after the assessment, that he wasn't, that it's voided.
All right. And we're going to have some other witnesses talk about the meeting where this decision was made to refund Mr. Burns, but I just want to be clear, you were not on the board.
No, I wasn't. If I'd been at that meeting, I would have been verbal about that, but no, I wasn't at the meeting.
All right, very good. That's all I have for this witness.
Mr. Olson, do you have any cross-examination of Mr. Hatch?
I do, thank you. Just a couple of questions. Mr. Hatch, that resolution number 12 that we just looked at, it says that the $16,670 is due on September 1st, 2009, doesn't it?
Mm-hmm. Yeah.
Okay. And Mr. Burns' prior owner defaulted in his payments, didn't he?
That's what I have heard, yeah.
Okay, that's all I have. Thank you.
Okay, thank you. Any redirect, Mr. Vial?
No, thank you.
Okay, Mr. Hatch, your testimony is done.
But John, you can stay on. You don't have to, but you can.
Mr. Vial, will you call your next witness, please?
Yes. Mary, could you please unmute?
Hello.
Hello, Ms. Saunter. I'm going to swear you in now. Raise your right hand. Thank you. Ms. Saunter, do you swear or affirm that the testimony you're about to give in these proceedings will be the truth, the whole truth, and nothing but the truth?
Yes, and it's pronounced Sofner.
Oh, I'm sorry. My apologies. Thank you.
Happens all the time.
Please proceed, Mr. Vial.
All right. Can you tell me when you purchased your unit?
May of 2018.
And I guess I should have asked you first whether you own a unit at Country Club Condominium. Which unit do you own?
Number 18.
So you purchased in September of 2018?
No, it was May of 2018.
All right. I'm sorry, are you a member of the association's board of directors?
Yes.
When did you become a member of the board of directors?
Probably May of 2019. Right. I joined after John left.
So you took Mr. Hatch's seat?
I guess.
Okay.
Yeah.
All right. Were you on the board of directors at the time that the decision was made to issue a refund to Mr. Burns?
Yes.
Prior to that meeting, did you ever attend a board meeting, or did you ever have any interaction with Mr. Burns in any other setting where Mr. Burns offered to forbear litigation against the association in exchange for the board issuing him a refund?
There were emails that he had been conferring with Eric Hogue, who was on the board, about the situation.
Right. But did you have any, and I'm just asking about you personally. Actually, let me back up here. How many people were on the board of directors at the time that the decision to issue the refund to Mr. Burns was made?
5.
And was it the board's practice to conduct all of the association's business in properly noticed open board meetings?
Unless we had to go into executive session for some reason, yes.
Okay. But as a general matter, if the board of directors was going to consider some issue of association business, you would only do that in a meeting where you'd send a notice out to the owners, and you would do it in full view of the owners. Is that right?
Yeah. It would have been, or should have been, on the agenda.
And at that time, was it customary for owners to attend those meetings to bring various topics or business before the board?
Yes, they had the opportunity during the open forum.
Was it pretty common that they did so?
Yes.
Okay. Did Mr. Burns ever come to one of these meetings and make an offer of any kind to the association to not sue the association in exchange for the board issuing a refund?
I don't remember a specific. He had, when he was there, the few times that I was there and he was there, and before I even joined the board, there was a lot of yelling, but I didn't take it in.
I
That makes
understand.
sense.
How did the board come to make this decision to issue Mr. Burns a refund?
Eric Hogue presented his theory of how he shouldn't have been charged the special assessment, and gave the evidence that supported his theory, and it seemed like it was the correct thing to do. But then we found out the next meeting that he failed to present the escrow papers that had Tom's initials and signature accepting the special assessment as part of it.
I see.
And
So at that first meeting where you voted to issue the refund, would it be fair to say that Eric Hogue characterized his proposal to refund the money to Mr. Burns as just the right thing to do because Mr. Burns is overcharged?
yes,
Okay. At that meeting, did Eric Hogue present to the rest of the board any sort of agreement between the association and Mr. Burns where Burns wouldn't sue the association in exchange for issuing the refund?
well, he verbally said it. He didn't have a written contract that said it, besides the demand letter that we got.
Okay.
So,
And this next board meeting where the board voted to rescind its earlier decision, the basis for that, if I understand your testimony, is that you discovered that Mr. Burns was aware of the assessment because you got a copy of his escrow paperwork.
yes,
All right.
and
That he bought the unit with knowledge of the assessment and accepted paying that assessment.
yes,
All right. And that's why the board members that had previously voted in favor of issuing a refund voted to essentially reverse that decision.
yes, exactly.
All right. I think that is all I have for this witness. Thank you.
Thank you, Mr. Vial. Mr. Olson, any cross-examination?
Yes. A couple of questions. Ms., is it Saunter?
Sotner.
Sauntner. At the July 17, 2019 board meeting, where the board voted to refund Mr. Burns, wasn't that vote unanimous?
No, Daryl Redman voted against it.
Okay. And at the next meeting, where the board voted to reverse that decision, how many voted for and how many voted against reversing?
I think the only one against might have been Eric.
Eric Hogue?
Yes.
Okay.
The rest of us, as far as I can't remember what Jenny voted, but I know Daryl and I and Fernanda all voted to reverse the motion.
And did any of the directors abstain?
I don't remember.
Okay, that's all I have. Thank you.
Thank you, Mr. Olson. Mr. Vial, any redirect?
No, thank you, Mr. Oliver.
Okay. Ms. Saunter, your testimony is now over, but as Mr. Vial mentioned, you're welcome to stay online if you wish.
Thank you.
Thank you.
And Mr. Oliver, I'd ask that we briefly recess while I attempt to get Daryl Redman on.
That makes good sense. Why don't we take, is 10 minutes enough?
Oh, that's more than enough, yes.
Okay, a 10-minute break and for all reasons, and we'll reconvene at 11:10. Thank you. Mr. Vial, were you able to get your next witness?
I'm afraid I wasn't. I know that Mr. Redman lives in a rural area with spotty cell phone and internet coverage. We may not be able to get him here. He's usually pretty good about responding if he's able to, and he has not responded to any of my messages or emails, and so I think we may have to proceed without him.
Well, that's unfortunate. Do you think another 5 or 10 minutes would make a difference, or?
It certainly might, yes.
Mr. Olson, is that something you're willing to allow?
Yes, of course. I'd be happy. So should we come back at 11:20 and see where we are?
Mr. Vial, does that sound acceptable?
It does. Thank you, Mr. Oliver.
Okay, so why don't we do that? We'll come back at 11:20, and hopefully you will have been able to make contact.
Very good. Thank you.
Thank you.
All right, Mr. Oliver, I was able to reach Mr. Redman, and it looks like he's connected now.
Okay, great, Mr. Redman. Are you going to just participate audio and no video?
I should. I think I've got video. I'm still learning this thing. Sorry.
Understood. If your connection is not strong, it might be advisable to just stay on audio and leave your video turned off. But okay. Well, there you go.
Okay.
All right. Mr. Redman, can you hear me okay?
Yes.
Great. I'm Jim Oliver. I'm the arbitrator in the matter, as discussed earlier, and it is now your time to testify. I'm going to swear you in, so please raise your right hand. I can't see your right hand, Mr. Redman. Very good, sir. Thank you.
Trying to find it.
Yeah, understood. Mr. Redman, do you swear or affirm that the testimony you're about to give in today's proceedings will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Vial, you can proceed.
All right. Good morning, Mr. Redman. Do you currently own a unit at Country Club Condominium?
No, I do not.
Okay. So, do you have any financial stake in this matter in terms of your obligation to contribute to the association's common expenses?
No, I do not.
Did you previously own a unit at Country Club Condominium?
Yes, I did.
Which unit did you own?
Number 9.
Have you served on the association's board of directors?
Yes, I have.
Okay. During what time periods?
Probably 2012 to 2020. Yes.
All right. So you were on the board at the time that the board voted to refund over $16,000 to Mr. Burns in 2019. Is that correct?
That is correct.
All right. Let's start with that. You were the sole holdout that did not vote in favor of that refund. Is that correct?
I did not vote to refund Mr. Burns.
Why was that?
A couple reasons. One, I did not feel that it was right to refund him. And 2, there was not enough showing of reasons why he never really made the request. It was another board member that put the motion up for discussion to refund him.
All right. Well, that takes me to my next question. So, did you... Actually, let me back up. Did the board typically do all of its business in open board meetings, where the board would come to a public place, discuss the association's business, and vote on how to proceed on various matters?
Yes, they did.
Okay. Did Mr. Burns ever approach the board and make some sort of offer to waive any legal claims that he might have or forbear pursuing legal claims that he had if the association agreed to refund him this assessment payment?
He did not personally approach the board directly. Anything that came through a second party.
Okay. That second party being Mr. Hogue?
Yes.
Okay. Now, did Mr. Hogue present the decision to issue this refund as some sort of agreement, or did he just present it as something the association was obligated to do because Burns shouldn't have been charged?
That Mr. Hogue felt that Mr. Burns should not have been charged.
All right. Now, you were a member of the association in 2009. You were a unit owner in 2009 when this special assessment...
That is correct.
Okay. And was it your understanding that owners had the option of paying a month-to-month special assessment or prepaying the entire amount of those monthly payments?
When the construction loan was converted to an actual loan, yes. There was an assessment prior to that, though, for just maintaining capital funds or operating funds for the construction loan.
All right. But after that conversion of the construction line of credit to a term loan, was it your understanding that owners had the option of either paying a monthly special assessment that was equal to their share of the association's loan payment or prepaying the entire amount of the principal?
That is correct.
Okay. What did most owners do?
Most opted to go with the monthly option.
All right. During your time on the board, prior to this 2019 meeting, did you have any interaction with Mr. Burns?
There were several lawsuits that he brought against the association and or the management company doing business for the association.
All right. And did Mr. Burns attend board meetings from time to time while you were serving on the board?
Yes.
Okay. Did he make any allegations of financial improprieties, accounting irregularities? Did he ever claim he was overcharged for his assessments prior to 2019?
His rantings, yes.
Okay. Is that something he did on a pretty frequent basis over the course of the years that you were on the board?
I would not say monthly, but it was frequent. I would say when he'd show up 4 or 5 times a year, maybe less. I can't remember that, but I know it was frequent. It wasn't every time he showed up, but it was fairly common that it would come up.
right. Now, we've heard testimony today that the board voted to reverse its decision to issue this refund to Mr. Burns at the board meeting immediately following the meeting where the refund was, where the board voted to issue the refund. Is that right?
That is correct.
Okay. And we've heard testimony today that that was based on the escrow closing statement that you provided to the other members of the board. Is that right?
Yes.
So was the board's decision to reverse its earlier decision based on the fact that Mr. Burns was clearly aware of the assessment and had agreed to assume that assessment when he purchased his unit?
That is correct.
All right.
Sorry, I was muted. Objection, leading the witness.
I'm going to overrule the objection, but ask Mr. Vial to ask non-leading questions. All
right. Well, we're all in luck because I'm all out of questions. So I will. I'll yield here, and if Mr. Olson has any cross.
Mr. Olson?
Thank you. No cross-examination.
Okay. So I assume no redirect, Mr. Vial?
Correct.
Mr. Redmond, your time as a witness is done. Thank you.
Okay, so I just leave?
Yes.
With the leave?
You can click off now. Thank you for your time.
Okay.
Okay, there we go.
All right.
Counsel, I don't hope this isn't too unorthodox. I have a couple of questions, and while I know that, Mr. Olson, you've rested your case, they may be best answered by Mr. Burns. So if you're okay with that, I'd like to put out one or two questions here.
Please.
So the exhibit that we have referred to a couple of times, the escrow demand statement, I believe with your pre-hearing statement, it was exhibit 1A-1. It's a 9-page document. And maybe Mr. Olson can answer this as well, but are you finding that, Mr. Olson?
Well, what I submitted yesterday was a 2-page.
Right, but I'm going back to your original pre-hearing statement. Do you have that available to you? I can jump back and forth. It may be that it's the same document. Maybe they were lumped together in the pre-hearing statement.
Is this 1A-2?
1A-1.
Okay.
9 pages.
Yep, got it.
Page 5 of that document.
Okay.
It says buyer's name not provided. Can we all agree that this is relating to Mr. Burns' purchase of Unit 28 at the relevant time?
Yes.
Okay.
I can agree, yes.
All right. And my second question, also about this same page. There is reference to special assessment in the middle of the page, due now and special assessment next month. And over to the right side, it says July through November 2010 SASS. Can anyone tell me what that stands for?
I'm sorry, where are we looking here, Mr. Oliver?
It's the escrow demand statement from Fidelity National Title. In Mr. Olson's pre-hearing statement of proof, it's marked as Exhibit 1A-1.
Right, okay, I see where you're talking about here. July-November 2010 SASS, and then below that, December 2010 SASS.
Yes, can you tell me what that stands for?
I can't. I mean, if I had to hazard a guess, the first two letters stand for special assessment, but I don't know what the SS means.
Okay. All right. Well, it's obviously then perhaps not very, not a burning question. Before you guys move to closing argument, a couple of other questions. There was a reference in the materials. Mr. Vial, you attached exhibits of the two lawsuits from 2017 at the circuit court level and the small claims court lawsuit from 2015. There was a reference to a 2016 lawsuit that Mr. Burns filed, but I didn't see a copy of that, and I don't know what allegations were made in that.
That was a lawsuit filed by the association seeking an injunction against Mr. Burns from harassing the association's landscapers. Mr. Burns asserted counterclaims in that matter. Ultimately, the court granted judgment in favor of the association following trial and issued the requested injunction. The counterclaims in that matter were, I believe, all knocked out on summary judgment. There was not a specific allegation of accounting improprieties, which is why I didn't include it. I just referenced it for the fact that Mr. Burns was represented by counsel at that time in a dispute with the association.
Okay, understood. Mr. Olson, anything to add to that explanation?
No, that's correct. That lawsuit had nothing to do with what we're talking about today.
Very good. And there was a reference to a January 2019 demand letter that Mr. Burns put to the association about the issue at hand here. Why was that not included in our exhibit?
Good question. I don't know.
Okay. Mr. Burns, do you have a copy of that demand letter?
Yeah.
Would you mind sharing that with Mr. Olson?
Let's see.
It doesn't have to be right now. I mean, forward him a copy.
Okay, yes.
And then, Mr. Olson, when you get it, you could distribute it?
Yes, I will do that. Thank you.
Seems to me that might have some pertinent information in it. And let's see. Checking my notes here. One other question, and for you, Mr. Burns. When you were talking about the email that you sent to Mr. Hatch in September of 2018 that said, "Since I am a post-assessment owner as you," do you know the email to which I refer,
yes.
sir?
Yes.
And you said that in your mind that was referring to interest. Is that correct?
That's right, because they were sending out collection letters demanding either the full amount or payments be made starting October 1st of 2018.
And that interest is stemming from the special assessment that's at issue now. Is that correct?
That's right.
Okay. Very good. I just wanted to clarify what interest you were referring to.
It's the interest that Eric Hogue and myself tried to expose and correct since 2012.
Okay.
And it ended up to where Eric, Cherie, and Harvey themselves had to sue. And, of course, Mike Vial accomplished a summary judgment again on the other claims, but they won on the financial element, which was the interest fraud.
And I'm sorry, Mr. Oliver, I'd have to correct that. This previous board member, Mr. Hogue, and Mr. Burns' girlfriend, Cherie Crawford, and two other unit owners did file suit against the association alleging well over a dozen claims. Judge Whipper granted summary judgment on all of the claims except for an allegation that the previous management company had improperly calculated interest on the special assessment. That claim was settled. There was no judgment on that claim.
Okay. And Mr. Olson, do you agree with that?
I do.
Okay. And so that means, Mr. Burns, you were not part of that lawsuit nor part of that settlement, correct?
Correct.
aware of the interest issue as far back as 2012.
Yes.
Interest stemming from this special assessment.
Yes. At 6%.
Okay.
It was a 6% rate, and the HOA had a savings account that was yielding 0.25%, and they had money there, and Eric and everybody was saying, why don't we use that money and get rid of some of the 6% debt? So it was ongoing with everybody here.
Okay. And when I listened to the recording of the meeting that was submitted by your attorney, I thought I heard someone say, and I'm not sure who it was, that the HOA had already agreed to refund any interest payments you had made. Is that accurate?
No, they didn't have to refund any interest payment that I made because they never collected it because of the fraud. The attempt to collect was October 1st of 2018 after the judgment, and that's when the
settlement.
They were forced to recognize that there was $200,000 shortfall for the HOA that we didn't.
So you never. I'm sorry, I broke my own rule. I spoke over you. My apologies.
That's all right.
So, Mr. Burns, you never actually paid any of the interest payments.
Well, I made the first payment.
Okay. All right.
I'm sorry, Mr. Oliver. I might be able to be somewhat helpful here.
Thank you.
Mr. Burns paid all of the interest that he was obligated to pay. So at any point along the way, while he was paying the monthly special assessment, he could have made a lump sum payment and avoided future interest payments because the association would have taken that money and applied it to the loan principal. The interest we're talking about here is was an improper calculation that a previous management company did where some owners were being charged too much interest and some owners were being charged too little. And they had to do a reallocation on that and collect some additional interest from some owners who had not paid enough and refund interest to some owners who had paid too much.
Okay.
And I don't know whether Mr. Burns has refunded any interest or not, but that issue did pop up.
Okay. Do you agree with all that, Mr. Olson?
Well, I don't disagree with it. I have no knowledge, though, so.
Okay, very good. So I think that was all of my questions, and I appreciate y'all's cooperation there. If we have nothing else to discuss, we could go to closing argument. Mr. Olson, would you like to proceed?
Yes, thank you, Mr. Oliver. The evidence has shown that at all relevant times, Mr. Burns was a unit owner and a member of defendant HOA, that Mr. Burns acquired title to his unit in November 2010 as a result of a foreclosure of the prior owner's trust deed. The evidence has shown that assessments against the unit or its prior owner became due prior to Mr. Burns' acquisition of title to the unit. In fact, the defendant's exhibit that shows resolution number 12 shows that the $16,670 was due on September 1st, 2009, and that was the testimony of Mr. Hatch. Mr. Hatch also testified that the prior owner had defaulted in payments to the HOA. Mr. Hatch also testified that he did not have to pay the assessment or the interest on it. Mr. Burns is and was not personally liable for these assessments. The HOA overcharged him in the amount of $16,670, and he mistakenly paid that amount. Mr. Burns did not discover his overpayment and could not reasonably have discovered it until sometime before the defendant's July 17, 2019 board meeting. It was actually in mid to late October 2010 at the earliest when Eric Hogue told him to check the Oregon revised statutes and that the board should refund this amount. And it was at that point that Mr. Burns began exploring this issue, sent a demand letter to the board through a prior attorney in January of 2019, demanding a refund of this amount, or he would sue. Regarding the paperwork that Mr. Burns signed when he purchased his unit, just because someone mistakenly says yes, it does not necessarily mean that they're legally obligated. At the July 17, 2019 board meeting, Mr. Burns and the HOA did indeed reach an agreement that the HOA would refund the full amount of Mr. Burns' overpayment in return for Mr. Burns not pursuing legal action against the HOA. The HOA has not refunded any of that money, and Mr. Burns would request the relief requested in his complaint. Thank you.
Thank you. Mr. Vial?
So, Mr. Oliver, I know that that you are very well versed in how statutes of limitations and discovery rules as applicable to those statutes of limitations work in Oregon, and so I'm not going to bore you with a bunch of case law on that apart from what I've submitted in my briefing. I would just point out that there hasn't even been a suggestion here that Mr. Burns learned some fact within 2 years prior to the filing of his suit. He was aware of all of the facts that would have put him on notice of any claim that he allegedly has years and years and years prior to his filing of suit. What he claims to have learned is that the statute says what it says regarding the discharge of the association's lien for assessments that were due and payable prior to a foreclosure. Learning of the existence of a law within 2 years of the filing of suit doesn't save you in terms of the discovery rule. When you learn of all of the facts that constitute the basis of your claim's accrued as far as the law is concerned. And I think the cases on that are pretty clear. But again, I would refer you to that case law, and I know that you already know it. So, moving forward here, as to this purported agreement, we don't have this demand letter and evidence. I can't swear that I've never seen it, but I certainly don't recall seeing it. And I'm going to reserve any objection as to its admissibility until I do have an opportunity to review it. But in terms of the evidence that you have here so far, it's clear that there was some discussion or maybe some sort of threat by Mr. Burns to sue if he didn't get a refund. Who that threat was communicated to, whether it was communicated to the entire board, whether the board made any decision on the basis of that threat, that's what we don't have any evidence of. We've got testimony that Mr. Hogue, who was Mr. Burns' advocate on the board, he convinced everybody that the board was legally obligated to refund money because they shouldn't have assessed this money against Mr. Burns in the first place. And the board went along with him. Later, they became convinced that they weren't obligated to pay that money. But there's no evidence whatsoever of a quid pro quo here where the association agreed to refund this money in exchange for Mr. Burns doing something. And that is the critical piece here. In order to have an enforceable agreement, there's got to be some consideration. And if Mr. Burns had provided the association with a waiver of his claims when they voted to issue this refund, then that clearly consideration. If Mr. Burns had decided to forbear litigation when they issued this refund, and then the board went a year and then changed their mind, said, we're not giving you a refund, and in the meantime, he blew the statute of limitations, that's probably consideration too. Here, where the board made a decision to issue a refund, and then at the very next meeting, made a decision to rescind their earlier decision, Mr. Burns still had all the same rights. He hadn't given up anything at all. The association had gained nothing in exchange for this initial decision to issue him a refund. There was simply no consideration at all for that. And Mr. Burns was not harmed in any way by his reliance on that original decision to issue the refund. So even if we would have had evidence, which we don't, but even if we had evidence that the association made the decision to issue the refund in order to avoid being sued by Mr. Burns, we still don't have an enforceable agreement because Burns didn't give anything up. As you've heard, Mr. Burns was well aware of facts that caused him to believe that the association was improperly assessing him in various different ways, was engaged in accounting irregularities, was not operating on a sound financial basis, and was assessing him amounts that they shouldn't have assessed going back at least to 2012. If he actually believed these things, he definitely had a duty to investigate his claims, including investigating the law that might be applicable to his claims. I don't think that there could be any reasonable fact finder that could determine that he didn't have ample opportunity to discover any claim that he may have prior to 2 years before filing suit. As to the resolution, Mr. Hatch testified as to what the resolution says. I've argued what the resolution says. Mr. Olson's argued what the resolution says. I would just ask that you read the resolution yourself and pay attention to the option here that the owners are given. And as Mr. Redmond testified, the option is pretty clear. If you wanted to avoid having to pay any portion of the interest that the association was going to be obligated to pay as a common expense, then you had to make a lump sum payment. And that lump sum payment was due September 1, 2009. If you did not want to make that lump sum payment and you were going to be on the hook for payment of that share of the common expense, the association's share of the interest payment for the entire term of the loan, then you could not make the lump sum payment. And then your obligation is to make a payment each month in the amount of the association's principal and interest allocable to your unit as a common expense. That common expense arises each month when the association has a loan payment due. Your assessment obligation arises each month when you are assessed for your share of it. Those are the two options. Apparently, the former owner of Mr. Burns' unit opted for the second option. And so any payments that would have been due and payable prior to the foreclosure wiped out by operation of the Oregon Condominium Act. The foreclosure would wipe out the lien that the association would have had for those assessments. However, as soon as a new owner takes title and becomes liable for assessments generally, they also become liable for their share of the common expenses as it relates to this loan payment. The bank knew it, the title company knew it, and I think we can safely assume that if the lender thought they had any argument that the future buyer would not be obligated to pay this special assessment, they would have made that argument because the unit would have been a lot more marketable without an additional $225 a month special assessment. If they could have sold the unit without that assessment attached, they probably could have sold it for more. So if that argument existed, it would have been made back when Mr. Burns bought his unit. And with that, I think I will I'll rest. Thank you, Mr. Oliver.
Thank you, Mr. Vial. Mr. Olson, any closing remarks?
No, thank you, but I would ask you to consider the written demand that I will send around once Mr. Burns sends it to me.
Well, I may have overstepped in asking for that, and I will allow Mr. Vial to state any objection to its admissibility. I just thought it might shed some light on the issue. So if we're done with closing, what I'll tell you is my normal practice for arbitrations, court annexed arbitrations, is that I'll get you a decision in a few days. What I normally do is contact counsel, let them know how I'm going to rule, and then allow them, say, a week to talk between themselves and see if they can reach out an agreement, knowing what the decision will be. And in that way, it avoids anybody having a judgment filed against them at the court. If you guys can't come to a settlement, then I'll file my opinion in the judgment for this arbitration hearing. If you can, I'll just notify the court that the parties have reached a settlement and we'll be done. Is that acceptable?
Yes.
Yes, Mr. Oliver.
Okay. I've found that, 8 times out of 10, once the parties know how I'm going to rule, they're able to reach an agreement. So hopefully that will come to fruition. I will hold off until Mr. Olson circulates the demand letter, and then if we need to, perhaps Mr. Olson, Mr. Vial, and I could have a quick phone call and or Zoom meeting to discuss whether or not I should consider it. My general rule is pretty lenient on accepting evidence late, even holding a record open to get relevant evidence, particularly in arbitrations like this, but I'll hear any argument against it. And with that, I think we're done today, unless counsel has anything else to add.
Nothing for me, thank you.
All right. Well, I thank everyone for their time and thank the counsel for their professional presentations. And we'll be in touch very soon. Mr. Olson, we'll look forward to that letter being circulated whenever you can.
Thank you.
Okay, thanks. Have a great rest of your day.
Thank you. Bye-bye.